Good morning, everybody. How are you doing? We got to sleep in an extra hour. I hope everyone's doing good today. So, we're starting this off with a really stacked bingo. Let me get into chat and put in the link. It'll take me a minute. As you know, it's so early. Can you guys? It just dawned on me. Maybe you guys can't even hear me. Maybe the birds are louder than I am. Hi, Marky. Thank you for letting me know. Okay, let me get up in here. It is 6:25 a.m. on the West Coast, but on the East, it is not. It is 9:25 a.m. Oh, good. I'm glad. I'm glad the birds are so excited to be here with you guys. Um, Coming in. Hold on. You guys know, first of all, let me just explain something. I have no caffeine in my system. I'm like multitasking once again. Only thing I do really well at multitasking is drive. Okay. Okay. I'm coming in. I'm coming in. I wish I could pin my own link, and that would be amazing. And good morning. Good morning. We are here. Actually, let me take us over by the modem. 1 second. Lana's in chat. Good morning, Lana. I'm just going by the modem over here, trying to get a little bit of a better stream. And maybe get some tea too. Although I could do that without. Okay, hold up. Lana, if you're in chat, tell me if you can pin it when I post it. I'm just morning. Morning, Lana. Where's the fire, Paul? No fires. I think raindrops keep falling on your head, in my head. There, see if you could pin it. Good morning. Why is it doing this? 1 second, please. Yuri's math teacher, thank you so much. That's so kind. Thank you. Welcome, honors. Thank you, Yuri's math teacher. Good morning. Good morning, Karen. Good morning, all you pretty fresh faces. Good to see you in here. Today we're going to be outside the presence of. You want to hear me get my tea? Hold up. Let me see if it's ready. I'm brewing some tea right now, like with tea leaves. It's some Persian cardamom tea. We are going to be outside the presence of a jury this morning. And we are going to be going over I think we're good. Okay, no, I need caffeine because now this is what I did yesterday morning too. I forgot everything until I got caffeine in me. God, it's literally a drug. That sucks. Okay. But I don't know if we're going over the curative instructions today. We're gonna be going over motions, I'm sure. Karen, thank you so much. Karen, you are a doll. Thank you so much for always supporting. You are a highlight of the day with your sweetness. We'll be going over, hopefully, Alessi's motion. Alessi was writing all day yesterday. Like, just his hand must be cramping, you guys, because he did not even look like he was going to give up. Like, he had no give up in him. And that matters. He believes in her innocence. You did, Elo? That's amazing. Can't wait. Oh my God, that's a hot ticket. Aw, we love you. We love you, Karen. Alas looked like on his face, because I do body language on the side and only on Sundays, but I'll just give it to you guys today. Um, that man looked determined. He was writing that. Like notes for emotion. I have no idea. He was literally just, that's what he was doing. Alo says, thank you for the super chat, Karen and Yuri, with the members. I am too, Candice Marie. It is just a shit show over there. I've never cussed this much on streams in my life. Sometimes I have a potty mouth, but like not on streams, man. That, especially early in the morning, I usually don't even have energy for that kind of talking. I'm kidding. I'm not kidding, but I am. I don't know. Okay, I got my tea. 1 second. What do you mean, Green Acres? Where have you been? This is Bella. Man,
Early bird gets the worm, bitches. Take that and shove it. Yeah. From the courthouse. Look at that pretty building. Look at all these pretty buildings. That's where Jose Baez did the case 2 years ago with the doctor. Yeah, right there. God, everybody's just up and after it this morning. Who doesn't want a Euro at like 9:30 a.m.? Good morning, Reed trial watchers. It is never a dull moment. Karen Reed, free Karen Reed. We're having a standout here in Columbus by myself. You guys, what if I just start chanting? Just meet me at the hot spot. Franklin County Government Center, baby. Right over there. That's the law library back over there. I'm going to just start chanting, free Karen Reed! Free Karen Reed! People are going to be like, what is on around here? That's where I whipped Lala's ass, right there, Franklin County Common Police Courthouse. She brought her happy ass to Columbus to get her ass beat in a courtroom. She could have done that shit on Zoom. There's Dempsey's.
She was excited to be there.
Oh, God, yeah.
She was so excited whenever you'd go up to her, like the
approach. To introduce a piece of evidence?
Yes, like just so excited.
Yeah, baby! Failed. It's gonna be a hot one. It's gonna be a hot one here. It's Pride Week. I'm trying to see if any of the gays were out.
I thought it was Pride Month. Why are you taking 3 weeks away from them?
Well, it's in Columbus here. It's Pride Week this week. I mean, it's all month, but they like throw down in the town.
Oh, we're about to lose you, little. Oh,
Thank you so much. Do you take tips? Are you allowed to take tips? Are you allowed to take tips? Thank you so much. Keeping our place clean.
Thank you.
I appreciate you. Thank you, sir. Right there. People don't people enough.
No one gets thanked enough. You guys, the juror spoke last night and literally said everything that I said to you guys yesterday. We call it Stockholm syndrome, but
right?
It is. What? Free
Karen Reed! Free Karen Reed!
People in Columbus.
I'm having my own standout. Because I don't need nobody. I'm a trendsetter, baby. I don't need groups.
She's like,
thank you, sir. Looking good. Looking good. You're welcome. Look at our buildings.
Look at our building.
Look at that. Look at that man doing that landscaping.
You're so cute this morning. Something is wrong.
It's a one-stop shop down there. There's the Juvenile County Intervention Center right there. I mean, you got it all. Just right here. It's just the Criminal Justice Center. Now if I can only find where I parked. Saw some guy getting his car towed. Felt really bad for the bastard.
Yeah.
Yeah, buddy. Looking good. Looking good. I'm going to ask this guy if he's a lawyer, if he has a business card. He's a civil rights advocate. Do you practice law? Do you have a card on you? Do you do, what kind of law do you do?
Criminal defense.
Oh, you do?
Yeah.
Okay, do you do any, I can give you a shout. Do you guys do any, like, civil work?
Not really, not anymore. I can get your referral.
Okay. Yeah, I'm looking for a really civil rights
Yeah, Jeff Moore is the only person that I know in town that I think is competent to do that. That I'm aware of. I'm sure there's others.
Okay. And your name was?
Adam Burke.
Okay, thank you, Adam.
Yep.
Have a great one. Okay.
Did he say?
I was about to say, are you looking for a PI?
I know. I don't know why you're like talking about civil and not saying. He said he's a criminal defense attorney, girl.
Yeah. Come
Get
on
it.
now. I don't need no criminal defense attorney. Just don't break no rules here. Well, the only rule I'll break is a jaywalk every now and again.
You guys don't give tickets for jaywalking in Columbus. That's LA. So
God.
what?
I'm just getting my steps in, guys. I'm so jacked on my accomplishments. Right here, baby. Right here. This is a golden ticket.
It actually looks golden light.
It is golden.
It's what you
It's
think
golden.
it is.
All right. Good morning, everybody. We're free and
Look at
can
our
read.
beautiful. Look at our beautiful buildings. We can read. You guys, I want Alessi to get up there today and oral argue the panties off Bevy.
Oh, it's Thursday morning. Oh my God, you guys want me to take a moped around? I get a GoPro on.
I
Look at
want
these
to know
cool
if
bikes.
you take a moped around, I need you to turn the camera on you. So if you fall, I can like get it on video and then we can watch it later and laugh.
You know whose office this is right here, right?
If it's who I think it is, I will even not say anything. You made me so freaking nervous.
Look at these bikes. Do they go by themselves? Oh, somebody left their. What's that for?
I'm telling you, if you fire one of those up, you better turn the camera. Are you thinking about it?
I thought about it. Woo! You carry me, baby. I see you over there. You know who she is? Girl, what you talking about? These bastards just waiting to tell a motherfucker out here. Look at that guy in the orange shirt. He just cannot wait to ticket in tow right there. That's all he does all day.
Let's take some wagers in at what time today. The jury isn't there, you guys, right?
Yeah, the jury's not coming at all.
So this is all OTJP, outside the presence of the date. And what we're going to see is Bev making us sweat, making us wait a little bit longer before she takes the bench. Or do you think she's going to take that bench at 10 a.m. Eastern Standard Time or whatever it is?
Thoughts? I'm going to go with 10:10.
10:10? Oh, so you think she's going to be earlier when the jury isn't around?
She already starting an hour late.
Jury's not even... Okay, but I just think... I think she had to lick a few extra ball sacks last night, and she needed to recover this morning. She had to make a pit stop.
Woo. Already smoking 85. All right, who's this? Adam Burke. We'll be calling your ass.
We'll be calling your ass out. You seem incredibly ready.
He seemed incredibly helpful.
Okay, you guys come in with yes. Let's have these predictions of when you think.
Really quick, as they're predicting in the chat.
You cut out. Okay? Can you start again? Yeah.
Oh yeah. So it's a bingo. So it's a double though. So I mean, are these people serious? How they parked behind me?
Okay, well then hold up a sec because you didn't pin my sheet.
Oh, I did.
Oh, you
It didn't
did?
pin. Yeah, go on. Come on now.
Oh, you did. Jeez. Psych. Just kidding. Yeah. Tell us about the bingo.
Yeah, we're doing double bingo, $25 winner out the gate. And you can use a free spot twice. You just 2 bingos on your scorecard.
Okay. So double bingo.
We're gonna have this game, and then tomorrow there'll be a game because during for the proceeding. So we'll go out with a bang. Dude, it's already hot as balls out here.
Murky's got it. As long as he's got it, it's in my brain now because Murky's like my backup brain. She's my full brain for bingo, apparently. Love me, Murky. You just do it so right. Trish, I think that's a fabulous idea, and I think they're going to do that. Lana, she says, can you do a live with Andrea Burkhart talking about the bingo results y'all did before trial?
Oh yeah, like our results, our pick'ems. We'll get her on the ticket. Thank you so much, people. I didn't have to cuss nobody to get over. Oh, Jesus. Oh, boy. All right, let's talk about it. So, one in the chat, if you think, if it's going to be 3 hours, we're going to have a verdict on Friday. I'm going verdict on Friday.
But you're also going dumbasses on jury.
Yeah, but I do think there's dumbasses on jury. The difference here is Hank's decorum is nothing like how Lally wasn't being the way that Hank was. And I think it was a big turnoff even for the jackasses.
I'm saying if it's handed to them on Friday, I'm saying they are coming back at 4:44 with
on Friday.
a
So
not
verdict on Friday.
guilty.
Yeah, I think that I think if Lally would have presented Hank's case, they'd have a better chance.
I mean, he took away his what if anything.
I just think that this trial should show everybody how important it's one thing to have really good witnesses as far as like their credentials. They're just not. Some people are good when they testify and they come across as being, like you said, like if you're an expert, you're impartial. But if you're just a fact witness, it doesn't matter who's asking the questions. You're just delivering. And so I think this trial for me just really reinforced how much it matters to keep it about the issues, keep it about what it's about.
Oh, damn. The fan's here. You 10 minutes.
What was that? Oh, we got a fan.
Yeah. It's incredibly, the jury's watching your demeanor when you're a fact witness or you're an expert witness on that stand, and you should not be there to bolster any side. I mean, unless like you're a family member and they're going to be asking you questions and it really, it has an effect on you.
Well, emotions is one thing, but I'm talking about like Kelly Deaver. I'm going to call her Deaver because I want to.
Yes.
Think about how amazing it would have been for her if she would have just said, yeah, no, I wasn't called last trial, but if you guys think that I have something to offer, but to say I don't know why I'm here. Like, really? Like, no. You're here because it's your job. first of all, number one.
Exactly.
Like, it's your job when you become a police officer to know that, hey, guess what? You're going to be testifying in court. You could. And so to sit there and say, I have no idea why I would be here. Well, that's the biggest, like, you're an idiot.
Well,
You're
yeah,
absolute
you just proved that you're an idiot because
Sorry,
everyone.
but you are. You're just
Exactly.
trash. She's trash.
Trash. Well, the one thing he
And
did
let's
was
talk
get
about how
my
she
name
makes
right.
$80 more thousand a year. Oh, did this thing cut out?
No.
I'm probably going in and out. I'm gonna leave and then I'll be back.
Okay, but you weren't. But yeah, go ahead, do whatever you need. Yes. Deaver Endeavor was incredibly hostile on that stand, and you're not there to do that, and that gets picked up by the jury. And you guys weren't in earlier. I think I'm just gonna talk about it. Actually, I let's talk about what's gonna happen when this gets to the jurors. I think, again, what I said yesterday stands, that these last few expert witnesses, but fact drops all day witnesses were amazing. You weren't cutting out a little, but yeah, come back in. They cinched it up. They wrapped it in a bow. They did what they needed to do, what they were there for. They weren't getting rattled by Hank. But let me just tell you guys something, like, if you don't know, while it looked like Dr. Rentschler wasn't getting that rattled, his body language was, by the end of the day, getting rattled. And if Hank, or as a criminal defense attorney, if you're a high caliber, as Hank was before, if you're a high caliber attorney, you're going to know body language. You're going to know how to read people. And when he started doing that, I was like, oh, shit, no. Because Hank is seeing what's getting under your skin. And when our brains, even if we're trained to know what not to do, like, our brains can't handle an overload of stress. And Hank is an annoying motherfucker. Excuse my language. He's annoying. That's what he's good at doing. He likes to get under your skin. And it started showing on Rentschler. And I was like, Hank sees this and he's just going to keep plowing in. His voice remained calm. But I don't know. It made me, like, really sad that he was under stress. But who wouldn't be with that joke? 5 green acres, that's what I said yesterday. Maybe the other day. I need more caffeine. Seriously. I would be so annoyed. Like, literally, who brought you to this restaurant? Excuse me? Honey, we're just out eating. I want to know, did you take an Uber? You brought me, hun. We came in the same car. But did you say you wanted to take an Uber if you were married to Hank? It'd be a shit show every day. And imagine how big his head would be right now. Like, you would just want to knock his block off every day, all day, all day. Yes. We are Girl Ryan. We're going to see not deliberations. We're going to see some oral arguments today. So we're going to be outside the press jury today. And we are going to be talking motions and probably the cumulative. And then after this live, I will read on my channel the instruction motion for the cumulative if that's all you guys want, is to hear that read.
She's back, bitch.
Hey, that interview last night was literally everything that I said today about what the jury thinks of Bev. The juror confirmed everything I said. And that's how they think of her. She said, the juror said, Bev, I mean, it's sad, she said, but it's true. Bev is that gives us our breaks. Bev is the one that, tells us we can go to lunch. And that's how it is, you guys. It's Stockholm syndrome. Bev is their point of contact. Take all of your theories out of what you think about the case. Pretend like you don't know about the case that much. And then you walk in there and she smiles at you every day, gives you your food. The bailiffs listen to her and they're attending to your needs and letting you pee. It's Stockholm syndrome.
Okay, so I want to speak on the juror a little bit. The juror from trial 1, juror 3, she's the one that got booted for allegedly going to one of the bars around town and drinking 6 weeks before this happened and supposedly talking about the case. That's the juror that was on Turtle Boy last night. So first thing is she said that Ronnie, we call bullshit on some of the stuff that Ronnie was saying. So I thought that was hilarious. And so they went through the different witnesses, but the first that they talked about was kind of like Bev, thinking of Bev. And the juror said, well, I didn't like the whole we'll let them have it thing. Like, what do you mean you let them have it? Like you're tossing them a bone? No, isn't it like if either it's proper or it's improper? And it just did not resonate well with her, as well as others. And we've been saying that since day one. And in trial 2, that's clearly stopped, because I think that Alan Jackson and the team said something to her about that. Yeah, I'll let them have it. Hear it from her to say, she's like, I know nothing about law or anything like that. So she's just like, it's just from a standpoint of, it seemed like she was biased towards, the defense, and she was with Commonwealth, and that's how it came across. The other thing that she was saying is that, she, for this trial, for the last trial that she was a part of, she said all the Alberts and the Higgins and the McCabe stuff, she's like, that's what did it for me in terms of just everybody's lying. Like, there's not anybody that's believable. Everybody's lying. And she mentioned the whole taking the phone and you're going to take it and throw it in 2 different trash cans in a military camp, military blah, blah, blah. And so she's like, she nailed it with saying the evidence is there. There's tail light there, there's this evidence that's there. And either believe in the conspiracy, okay, or there is evidence that's there that could convict Karen Reed. And that was just so perfect led, because that's why I think someone like a Jennifer Coffindaffer can't get around, who's like, a cop, FBI, law enforcement, is that this case is, I think, just so clear and cut. And she said it, she's like, Karen Reed's getting railroaded. She's like, in the second trial, she's like, the Commonwealth, both sides she thought had put on a better case. But at the beginning, up and until the defense started their part, she was like, I almost thought about calling Karen, because she was like, she's like, this is not to her, because she's like, it's looking like she did this and she did not, but based on the way that Hank did this, like we've been saying, like it's just totally a different case that they're putting on, and they're railroading her. And then she's like, so nervous is all get up for Karen, because knowing what I, that's what she was saying, knowing what I know. And, but then she's like, but now that the defense put on their case, she's like, the defense even put on a better case than they did last time. And La Posada was better than Sheridan. So she was just comparing witnesses, and she said that she went back to the 180, that it's at first she was scared for Karen because of the way that they were presenting the evidence, the Commonwealth was, but that Karen's team, and she was like, I thought about because she had talked to Karen's team after trial 1, and she's like, I just wanted her to know how it looked from someone like her, and she just didn't want. But then she's like, once the defense put on their case, then it was like a 180. And I think kind of how that resonated a lot for me, because that's exactly what I kept saying as I was like, dude, these jurors have no idea if they truly picked an impartial jury. That evidence and the way that Hank cookie cut it looks like Karen Reed hit him because of his phone just stopping dead in the tracks, and the whole pocket state and stuff like that. It was very compelling until you go and put your dents in.
Excuse me. Allergies all day. What I liked about what she said was that she first thought someone who strongly believed and sat on the first jury that Karen Reed is innocent. And she said, if I remove all that and I'm looking at this new trial, it's a new trial. When Alessi was asking Welcher questions, it's Turtle Boy and basically says Welcher is very believable because Alessi is basically being really overpowering, and I don't know the adjective she used, if rude or whatever, but she didn't like the way Alessi was asking questions to Welcher, and he was believable. And she says right now, as she sits here today, she does not believe that at all. She believes that the defense proved their case and that it's done for the Commonwealth, that they didn't prove anything. And that was done, what I've been telling you guys, by the last few witnesses, the last few expert witnesses who are so relatable, who resonate so well with that jury. And it's made its mark. Did you catch that, Lana, that she basically said Ronnie, the juror, was a liar? Yeah. Presented himself as being in the innocent camp, but he wasn't. He was for guilt.
He portrayed himself as one of the innocents. And I was like, well, but I think he did though say he was a flip-flopper, he was innocent then guilty then innocent.
She made it out like he never wavered from guilty and he left there feeling guilty. I don't know. I mean, I guess she wasn't allowed to deliberate because they kicked her out, because I guess she was so expressive. This was the juror that was so expressive. They called her in, somebody ratted her out and said, we heard her at the bar and she was talking about this case 6 weeks ago, whatever it was.
Look at this puppy.
Oh, is that the shirt? Oh my God, you put it up. Cute. Can't wait to hear it.
How you like me now? It's this close to being done.
I can't wait.
Yeah.
This is bye.
Hi guys. I'm just on a world tour with my mic in my hand. So I'm going to pull up stuff to do. I have a whole list of how I want to handle today. So we'll go through my checklist here. I believe that they're going to go over the exhibits and review those exhibits. Then they're going to go over some of the jury instruction because both camps put in their proposals. Then they're going to oral argue. That may be first. If they oral argue charges, they're going to make a push, I think, to get murder off the ticket.
Murder is a ticket you gave me.
Well, because I went and pulled up from last night, I was looking at some of the motions again because I wanted to see what Alessi's wording is that he wants Judge Canone to say about what happened with like the whole sweatshirt. And let me take a look. See, and I think it's great because it calls out Hank being a liar. It says that he wants the wording to be very, hold on one second. Okay, yeah. He wants the wording like this. On June 9th, Your Honor initially proposed the following language outside the presence of the jury. Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt, and I instruct you that those holes were made by Hartnett during the course of her inspection and sampling on May 18th. The court then instructed the jury with the following language. So, jurors, I instruct you that those holes were made by the criminalists, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt. So I instruct you. She said that. Now he says, this is how you propose it. Ms. Reed respectfully proposes the following language to address the misconduct and its harm to Ms. Reed. During the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the shirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29th, 2022 from a fall backwards. I instruct you that those holes were not present on January 29th, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police Crime Lab, in the course of her inspection and sampling of the clothing on May 18th, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29th, 2022. This is going to be huge because Alessi is going to be oral arguing in front of Bev today that he wants this to be said to the jury. Yesterday, the court agreed to enter into evidence and allow the defense to display Y, Z, 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 A, B, B. This has not been done yet. This information regarding the clippings from the crime lab still needs to come into evidence and be displayed to the jury. It unequivocally establishes Maureen Hartnett cut clippings out of the gray hoodie sweatshirt, Exhibit 88, and that the damage was not from any alleged event on January 29, 2022. That is also why Hank Brennan, you want to talk about rebuttals, why Hannon did not rebut. They were going to use her for the DNA to rebut stuff. Brennan couldn't because of what he did. Basically, like that would have come out.
Yeah.
It'd be big time. Then the other thing that he was going to have is Dr. Welcher was going to rebut Rentschler. And this is just my personal feeling, my going, is that once the x-rays came in, if Dr. Welcher never saw those x-rays, he would have blown up it would have been a catastrophe. Can you imagine if you're shown x-rays on cross-examination and asked if you considered those? Did you ever see those?
You are unmuted.
We're at 8 after. No, I
Look at,
amazing.
come on, Bev, just come on, give me 2 minutes, just twirl around.
She won't. Don't.
Okay, here we go.
Okay, please. For the record before the court is Comoff versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Kennedy from Karen Reed.
Good morning, Ms. Eddy, and good morning, Ms. Reed. All right, so Ms.
Where's Mr.
Gianetti and
Jackson?
Mr. Alessi,
Jay
you're
and
standing
Little.
in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off today was whether KKKK for identification. The PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objections, so it is excluded from evidence.
PowerPoint.
So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Charge conference.
I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding.
Yeah, I'm going to mute you when you're not talking because of the birds.
Okay.
Oops.
Is on
Wrong
this. Evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is the judge, 5 or 10 minutes.
Take your time.
Thank you.
Oh, okay.
We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three evidence may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning on January 29th when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scotti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case, expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case. That's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake part of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the wall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 8th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police at Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen didn't hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all three indictments.
All right, thank you.
Elo. Oh, Lally's going to go. Elo, keep your hands away from your screen so you don't glitch.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples. When it came to Officer Barrows, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which is consistent from the video or the photographs within the Sallyport. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. Labasada talking about the drop in body temperature, conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also back to a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the The cruiser camera video drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
So, Mr. Yannetti, you know I have to view this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth burden, so the motion's denied.
Thank you, Your Honor.
Okay. All right. So regarding the charge, so we'll start with the defense missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions with shorten things.
Oh, okay. So everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence. We're withdrawing that.
Okay, I had a question about that. Thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy.
That's Mr. Molesky's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand what the court's position might be on this, but it's the instruction related to murder charge. The Commonwealth is only seeking instruction on for the problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions are sort of the general instructions, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though I think it was, and I was upheld on it. So I will make it crystal clear. Okay? So I'll give you that, Ms. Giannetti.
I will pause that for a second, please.
This what is evidence. I probably won't give verbatim what you have. I'll take.
Okay, I'm going to try to bring in a different screen here.
Do you want me to go to?
I'm going to go ahead and I'm going to try this like this. So go. Okay. We'll see if it works.
I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the
doing the same
each
thing.
Individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it, so I will make it crystal clear. Okay? So I'll give you that, Ms. Giannetti. Is what is evidence? I probably won't give verbatim what you have. I'll take at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last, I think it's a little more robust than this. Take a look at it, but I will certainly cover all these topics.
Go ahead and press play.
So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, I want to take a look at what I gave last year. I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right? Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from the defense, not from actual evidence in the case, not from testimony from witnesses who stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and arguments are based or predicated in law evidence, not obviously, of course, well aware there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually evidence in this case. There is no basis whatsoever for not only a Bowden or third-party culprit instruction, but specifically for even counsel to make that argument during the course of closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to pack the evidence. Custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue other suspects, specifically telling his friends that the home was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for liberation of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it, we were
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did.
Okay, so just so that it's clear, You all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowdoin. Ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that, not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
I understand the distinction, Your Honor, and we're strictly going with a Bowdoin defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
And that's really what I was seeking, this clarification.
Yeah. Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to comment on that section for the DG instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Giannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously, it's not the strongest DG Batista argument that we would have would not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So I still think we're entitled to.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded.
Closing arguments are tomorrow.
Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument to be considered custodial.
All right, what do you say about all this, Mr. Hill?
And I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to the issue of custody and my client being able to deny it.
All right. What do you say?
And it's the very nature of the objection, Your Honor, is the non-custodial nature of this. So
Speak up, you fucking fat ass.
at our parents' house, they did with a number of different witnesses on that day as well. So of course of that, they spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from eating. And it did not end to a custodial situation.
I ate shit and I can't talk quickly. Like, I just ate shit. I got shit in my mouth.
But I think that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same requested jury instructions, including main practice. And then following the DG and Batista language in the defendant's requested jury instructions, there goes on to all of these other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of the main practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and having testimony from the stand, that initially she said she was fine with answering questions, but they wanted him to any details. And then when the questions became more centered on details, at that point, and I know that's not evidence before the jury, but of course, well aware, she then down. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that rises to the level of these instructions. So I would ask basically that everything on page 8 prior to the relevant instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
Yeah.
I think that's a fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the.
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the vote that they saw on the view was not present on January 29th. We asked her to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it. All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Any language in there I would object to.
Okay.
We'll go with Rob.
Or someone else for law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language counts.
Okay, thank you. I'll do the photographs, the opinion testimony. So I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics. What page you on? Okay.
One suggestion there was indicate Commonwealth is photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle. Ms. Gianetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it, Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the almost request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The
Well, what
emotional
happens to the
impact
full site
photos,
or
humane
proposed jury instructions?
practice. We'll get
This
back
is
to
normal.
consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee.
What?
That's when I gave the prior bad acts instruction.
Aruba.
Yeah, but
She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
all right, I'll be back.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the prior bad acts being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on call.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
So the only,
1 second, let me just pull that up. Okay.
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these factors. So
Okay.
the Commonwealth here, the first two prongs are essentially extraneous in this equation, and you don't explicate them to avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to to do him grievance part of non-intentional. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon.
I will endeavor to do so, Your Honor. I don't have anything.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason. But I understand, and I don't really want to.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe. Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the panel.
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh.
But I'm going to give it to them now. Can I hand this to the court?
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced in evidence, Ron.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have them redacted, so we
Okay.
redacted. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor. If I didn't.
You did not.
Okay. We do have one. We've got given a copy to the Commonwealth. Can I hand
Okay.
a proposed copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So you
All
might
down.
recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clear, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser includers, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Law, in which he had similar issues. And I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy with a copy of the docket, but that may be somewhat helpful with the court's thinking.
Okay, was that on a murder case?
It was not, but it had to do with the felony motor vehicle homicide.
Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering. Okay.
Do you need an extra copy, please?
Sure.
This is the,
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
it's LLLL for ID.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional field instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, we would be seeking to make some argument or reference in this argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal tab in to her parents' residence in Dyton, and then certain statements made in reference from the various clips of the play of her statements.
Okay.
In particular, would be the one where essentially she says it's a certificate to her.
Okay.
Whatever the exact location is.
All right. Ms. Giannetti, do you want to weigh in on that?
Yes, quickly, object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other clips.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Giannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted. So any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah.
It should become ID.
Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally?
NNN.
Can it still be that?
Is it redacted the NNN? Or is it, no, it can say that.
Okay.
Right? Is this the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
Yeah,
So that has to
our
be-
thinking is it needs to be sent back to letters for
Yeah.
ID.
Yeah.
So it'll be marked MM for ID.
That's great.
And then the redacted version will now just become
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand, and then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, crime lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred, that's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Okay, thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
Fuck you, Bev. I'm glad he fucking pushed and got on that mic.
I'm not going to get into a belabored point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with the witness on the stand, things can happen, mistakes can be made. It was remedied, recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessio.
You're not the
Right.
barometer of what
Anything
gets
else?
considered, Lally. Fuck you.
Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise for the court, please.
All rise.
Lana, are you going to be streaming another?
Yes.
Goodbye.
Goodbye. Pause that.
I'm
Please and thank you. I want the fan on. Oh, okay. Oh, my goodness. Do you guys get the sense that Bev is sensing a quick verdict? I am sensing that Bev is sensing a quick verdict. Thoughts?
I think she just wants her anal beads out. So yes, but what I want them to do is to come back at 2:27 and with a not guilty and just slap them all up with it.
Oh, hell yeah. You know that Jen McCabe testified at 2:27?
She did this round?
Yep. It was amazing.
Oh my God. Yes. So tell us about it. Tell us about it. So people who are in chat that are worried that this isn't seems like it's not going Karen's way. It is because
It's totally going Karen's way.
yeah, they're done fucking around with
Wait,
these.
I missed that. I missed Stan there. I'm sorry to cut you off. But I just didn't know because I need to know. Did Bev say that she was going to allow the? Is she going to say that it was? Is she going to blame anything on Brennan? That he misled them?
I didn't hear her say that definitively. I don't see that is going to be part of the instructions. She's basically anything that the defense.
Wait, you're kidding me, right?
Did you hear her say that she was going to? Because
just so you know, there is no 720 motion yet. I don't know what 720 you're talking about.
I'm saying anything past 719. I said 720 plus. There's a plus behind the 20.
No, I'm just letting you know that. I thought when you wrote me that you wanted motion 720.
I say anything that drops today because I'm going to be doing a live to read it. And so I'm just going to read the motions. So I'm saying anything that drops.
I'll start handing you Colbert stuff.
As it drops, I have covered the stuff.
Okay, so first of all, let's talk about Hank cutting off Dr. Wolf when Dr. Wolf was mid-sentence and going to say about the cutting. He cut him off on purpose so that he could not answer that. And then I think Dr. Wolf's the one that pointed out to the defense, hey, that was from her cutting. That was from the person that did the lab work. I cannot wait when this is over. I want to hear about that because you know what I'm talking about, right? His testimony. I totally went back and double checked. That little sneaky bastard, Hank Brennan, knew that Dr. Wolf was about to say, he said the word cutting, and then he cut him off. He cut him off to talk about the back of the sweatshirt, knowing he needed to cut him off though, because he was going to then say about the holes. Like he did. Brennan thought he was going to answer the question differently. Do you get what I'm trying to say? And so he cut him off on purpose so that he could attempt to do what he was going to do.
100%. It also proves intent. It proves that.
That's what I'm saying. Like, this wasn't no accident. I mean, I knew it wasn't an accident then because you guys, I've been there. Do you know how long it takes to prep for people? You know what you're going to ask somebody. You have your questions written out.
Oh, especially when you're a seasoned attorney like Brennan is. He knows both sides. He knows criminal defense. And
you brought in that piece of evidence and you set it up back there. Okay.
Specifically.
And then Lally just sat there knowing. I mean, Lally, were you not involved? Like, that's the stuff that you go to the bar with. That's
so Laughlin. So was everybody knew on the Commonwealth side, not just Lally McLaughlin too. The chick also. Listen, it was intentionally done because here's the thing: nobody else that came on that stand was asked those specific questions. It was saved for Wolf. Those questions were saved for Wolf. Nobody talked about it. And when Wolf got up there, it was meant to discredit him because no matter what happens, Hank, Lally, they're scared shitless of these ARCA men. No matter how many times they got up there and said, we welcome when they get up there. We're not trying to stop them from getting up there. All pre-trial motions that they did in the arguments we saw before they took the jury, he was scared shitless. So he's discrediting him right now by doing that. And that's Wolf's reputation and his career on the line. So it matters.
Yeah. And so I just went and got this. It's rule 3.4, fairness to opposing party and counsel. B, falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. He knowingly
lied. Yes.
Yeah.
And hid. And it doesn't matter. Listen, when you're the Commonwealth, the state, what you're doing is pursuing justice. It doesn't matter. And this is the fairy tale. This is how it's supposed to be. And it is a fairy tale. It doesn't matter what happens. You're after the truth.
Wait,
If mid-trial you find out that that person you're persecuting is actually factually innocent, you're supposed to stop everything.
I was just going to tell you that.
Go to the judge and say, I'm sorry, Your Honor. We would like to remove our charge against this defendant because in light of new evidence, we have found that we can't meet the burden. That's what you do. And
Okay,
if
so
you guys
Rule 3.4, fairness to opposing parties and counsel. E is in a trial. So in trial, allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence or by a good faith belief. So remember when Alan Jackson said this was done in bad faith. Like, this is bad faith. So will not be supported by admissible evidence or by a good faith belief that such evidence may exist. Assert personal knowledge of facts in issue except when testifying as a witness. Or state a personal opinion as to the justness of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. Hank Brennan has literally taken the book and burned it in front of all of our faces.
Oh, it happens. But Hank Brennan, this is very egregious and it's in front of us, yes. But this is literally like nobody actually.
This is what you lose your license over.
Oh, they definitely should listen. That's why I keep saying the bar is not the lowest bar is not okay. Well, we're asking for a mistrial. No, that's just the standard. That's what you're supposed to do in a case like this. There needs to be sanctions. They need to be removed. Their bar licenses all need to be removed. They should never work in law again.
Okay, I'm going to go to Turboy's trial. So let's see if it is starting. I just want to start it from the beginning, and I think it hasn't started yet. I thought it was supposed to start 11.
Okay, yeah.
Let's see if it started.
He was giving out, that's what I said to you guys yesterday when I was reading, when we went in. He had given out his Zoom link, and I was like, I'm not reading this on the live. But yeah, see if you get a Zoom link.
Okay, so let's see. I can't believe there's not cameras in the courtroom. Why wouldn't there be cameras in the courtroom? Like, this is like...
I could look for the Zoom
This
link
is just as like high profile, in my opinion. In my opinion, this is everything, you know.
Yeah.
Let's see. I mean, I found it. I just don't know if it started yet.
Oh, sheesh. I don't know my freaking log in on my computer for it, but hold on. Let's go this way.
Here you go. Is
You got it?
Is there anything being played yet? I'm gonna shoot Mike.
Load. Okay, well, I'm gonna find you his link and I'm gonna text it to you, okay? So when I do that.
To get on the Zoom link.
Yeah.
Well,
I'm gonna see if he put one up today, but
I'll just show. Figured while this is waiting, I don't know if it started yet. So I'm gonna.
What's going on? Did he have to remove his Twitter? Oh no, I found him. Thank God. Like, what in the world? Okay.
Okay, I'm gonna mute you for a second.
Do it.
All right, you just mute yourself for 1 second. I don't think I can mute you. Okay, thanks. I want to see if this does feedback. I just don't think it's started yet. I'm just gonna, I'll just cash app Mike $20 and say thank you. It's just probably easier to do it this way. I just don't want a bunch of people on the Zoom link. Nor do I want to be blamed for anything that would be said on that link.
Under your name. It's a lot of pressure.
Did you hear Lana say, I'm like, Lana didn't say shit. We have so much to discuss on those juries. I think this is going to be a quick not guilty. This is a totally different case. Let's go ahead and do this. Also, I have a rundown of all the witnesses. I made a nice little spreadsheet for us. We're gonna be.
You did?
Yeah, we're
For
gonna
the
be.
turtle boy?
For the
For the turtle boy or for Karen Reed?
Karen Reed. I have my 24-hour pants on. I'm doing a nonstop Karen Reed analysis. Hottest mic moments. So once it kicks off tomorrow, it'll be a thread all the way through. It's straight verdict watch. Okay. I just know there should be a camera in the courtroom for his case.
I think there's a reason.
Okay, perfect. It didn't start yet. Perfect.
Okay. Didn't say it. Yeah. So this judge is taking a little bit more time. Turtle Boy's judge takes more time as it was supposed to start at 11.
It must be a thing in Massachusetts.
It must be a thing of getting rubbed down in the back in your chambers. So you guys, this is going to be handed off to the jury tomorrow, most likely.
Yeah. Okay, so most likely it's getting handed off to the jury. They're doing an early lunch, and the jury's going to have this by noon.
I'm just thinking of the shenanigans Hank does, and I'm wondering if he got his ticket out of town Friday evening.
No,
or if he booked it.
Jury will have this case tomorrow at noon.
Good.
Matter of
Here we go.
Commonwealth versus Dayton County.
Welcome, turn on, go away, please, thank you, go away, please, thank you.
You finished your direct examination, is that right?
I have, Your Honor.
Witness, can you take the witness stand?
Thank you.
All in the case, all in the case.
And do you swear in Madam After hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you very much. Good morning, sir.
Morning.
You're Colin McCabe,
That is correct, yes.
and you are related to some of the witnesses in the Karen Reed matter?
Yes, I am.
And who are those folks?
My brother Matthew McCabe and my sister-in-law Jen.
So back on 2/26/24, you were here as part of a group of people going to court in the Karen Reed case, right?
That is correct.
And it was a 2 o'clock hearing?
I don't know what that means.
So you were there in the afternoon, weren't you?
Yes, I was here.
All right, and so you know that the court goes till 1, there's a lunch break from 1 to 2, and then they start up again at 2, right?
Yeah, I have no idea what happened. They don't even open the
Okay,
door.
so do you know what time you were here with this group that day?
With the group, I know I was there in the afternoon. I don't know the time that.
Okay. How did you come to be informed that you should meet at that location?
I spoke to my brother and I said, I'll meet down at the courthouse.
And that's Matt McCabe?
That is correct.
Okay. What was your understanding of what you were going to be there for and what's going to happen that day?
I was coming in to support the O'Keefe family and the witnesses in the case. So, support group.
Have you ever met had you ever met Lindsay Gattani before that day?
No, I had not.
Okay, and when you got there, did you have any conversation with her?
No, I had not.
How many people approximately had gathered at that area behind the Registry of Deeds in your group?
It was a good sized group. It was kind of broken up into multiple groups, but maybe 20 or 30 people, maybe. I have no idea.
And was Paul O'Keefe there?
I have no idea. He might have been. I have no idea.
So, did someone introduce you to Ms. Gattani?
No, I never met her.
And you said it broke down into two groups as everyone came towards the courthouse. Is that right?
That is correct.
Who was in your group?
In my group, multiple people, I had no idea who they were. My sister, my aunt, my cousin.
What are the names, please?
My cousin?
Yeah, the names of the people that were in this group.
I don't know everybody knows in the group, but Kathy Faulkner, my aunt. Shannon Sullivan is my cousin. Megan McCabe is my sister. I think a few of my sister-in-law's sisters were there. I don't know their last names off the top, man, but Michelle and Denise and everybody else. I don't know who else was there.
What was your understanding of the hearing that was going to happen that day?
My understanding was it was a quick hearing that day, go in, see what happens, and then leave.
Okay. So you walked towards the courthouse from the Registry of Deeds, correct?
That is correct.
And which way did you walk? Let's say you're walking towards the courthouse from the Registry of Deeds. Did you go to the right around the building, or did you go to the left around the building?
Came up to the driveway side, so I think that's the left around the building. If you come from behind, but if you're looking at it, to the right. So it depends on what side you're on.
Okay,
So
so
where it's on the left side, you're looking at the front of the building.
okay, so can we say it this way, that you came up between this building and the registry?
Yes,
And that's when you came into the court?
that is correct.
What happened when you got inside the court?
When I got inside the court, I then went through the metal detector and everything, came in the building, walked up the set of stairs to where there was a group of people waiting to get into the court.
Did you see Ms. Gattani inside the courthouse at all?
No, I did not. She wasn't in.
Did you end up getting into the courtroom?
No, there were too many people and there was a head count on the numbers that can get in, so I was at the back of the line, so I did not get it.
To your knowledge, did Mr. Carney get into the courtroom?
Yes.
At some point, so just to set this right, you're outside the courtroom, but in the courthouse.
That is correct.
What did you do while you were in the courthouse waiting around?
Just sat there waiting.
How long did it take?
Wasn't long, maybe half hour.
And what happened after half an hour?
Then after that, when the court let out, everybody started coming down the stairs. I waited for the group that I was with to come out, and then I proceeded to fall behind them and exited the courthouse.
And did you see Ms. Gattani as far as exiting the courthouse at all?
At that time, I had no idea who she was, but she was in the group of people that was exiting.
So I'm glad you brought that up. A lot of these observations that you have, that you've offered, are from you looking at video and then realizing stuff later, right?
Me looking at a video and realizing, yes.
And one of them is figuring out who Ms. Gattani is, right?
Well, no, when we were in the back parking lot, I then found out who she was when we were back.
So did you recognize her in the courthouse or not?
Yeah, I saw her when she went into the courthouse.
Did she have a piece of paper in her hand?
Yes, she did.
And what was your understanding of why she had a piece of paper in her hand?
My understanding of what that was all taking place when I was standing at the doorway waiting to get in. She had said to the court officer that she had an order against Mr. Gattani.
Did you talk to Jennifer McCabe about Ms. Gattani at all?
No, I did not.
It's true that Ms. McCabe was with Ms. Catani on the way in and on the way out, wasn't she?
She was part of the group, yes.
Did you hear them talking?
No, I did not hear them talking.
Did you hear them approaching the courtroom?
No, they were in a different group than me.
So back to leaving. You leave the courthouse, and is it still two groups or is it one big group now?
When I left the courthouse, it was one big group.
So Ms. Catani's in that group?
Yes, she was.
Ms. McCabe, Jennifer McCabe's in that group?
Yes, she was.
And you're in that group?
Yes, I was.
And how many people roughly in the group?
I don't know, probably about 25 people maybe.
And when you were leaving, the hearing had concluded and a lot of people were streaming out of the courthouse, weren't they?
Yes,
Some people went to the right down the handicap ramp. Some people went down straight, right?
that is correct.
There was probably over 100 people out in front of the courthouse when you left, right?
It was probably more than that, sir.
More than that, okay. And you and your group went out of the courthouse and you went down the handicap ramp, right?
That is correct.
And you came to the bottom of the handicap ramp and you were jawboning with some of the protesters out there, weren't you?
Yes, some things were being said to me and I responded to the things that were being said.
Sure. And you called somebody retarded and you said something about somebody could be committed or something, or you're waiting for them to be committed, right?
Yes, might not have been the best choice of words at that time, and I regret saying that, but yes.
And as you're leaving, Ms. Catani's in your group and everyone's sort of walking together away from the courthouse, right?
Correct, to go across the street to where the cops are parking.
Right. So everyone's walking at first along High Street towards Dedham Center, right?
That's the name of the street. I don't know the name of the street, but
Well, let's do it this way. In the street in front of the courthouse.
yes,
You exit, you get to the bottom of the handicap ramp, you make a right, you're walking towards town.
yes,
And you're kind of walking towards this building,
yes,
but across the street.
correct.
Then you get to the crosswalk, you walk over to the same side of the streets that this building's on, right?
Yes,
And then you walk down that little street that's in between this building and the Registry of Deeds building, right?
yes,
So all this time, you're walking away from the courthouse
walking away from, yes,
and you're walking away from the Registry of Deeds building, I should say the front of the Registry of Deeds building.
well, no, technically when we're crossing the street, I'm walking towards the registry. And then as we're walking down the side street, then yes, I'm not walking away from the registry of deeds until I get kind of.
Okay, so you get to the side of it, you're walking along the building, away from the front of the building, right?
That is correct.
I'm gonna show you some photos. May I approach, Your Honor? I'm gonna show you these three photographs. I've shown these to counsel. Take a look, so tell me when you're trying to familiarize yourself with those. Okay, are those close-ups of you and your group leaving the courthouse?
Yes,
Are they fair and accurate representations of your group's departure from the courthouse that day?
well, this one here, yes, these ones right here, I don't know exactly where these are.
Well, do they show the same people that you were with that day?
There was multiple people there, it shows a few of the same people that I was with that day, I don't know if it's everybody.
And so can we agree this is a partial representation of some of the people in this group when you left?
Yes.
And also these judges in next group.
No, Judge.
Thank you.
Exhibit 41, 42, and 43.
You just take those back.
Sure.
Thank you.
There you go.
Thank you.
I wanted to see those pictures.
showed you, exhibit 41. Who's the gentleman in the red desk?
So we just authenticated them.
I'm thinking that's me.
And that's a picture of your group department, right?
That is correct.
All right.
So number one, he just
And then,
authenticated them.
exhibit 42, who do you recognize in the photo? That photo.
I recognize my sister-in-law.
Names, please.
That is Jen McCabe. Recognize, I don't know her name, but that could be my sister-in-law's cousin. And I recognize one of my sister-in-law's sisters. Not sure which one it is, either Denise or Michelle. Terrible one, you know. That's not which one they are. And I think it might be a side clue of maybe my sister, but I can't 100%.
Thank you. Exhibit 42 for the record.
Thank you.
Exhibit 42. And do you recognize in that photo?
See, that would be Miss Albert. One of my sister-in-law's sisters, Denise and Michelle. And then that's one of my sister-in-law's brother-in-laws. That's Bob. And then I see, looks like my sister-in-law's cousin. I'm not sure her name. I see the side of one of my sister-in-law's sisters, which is Denise and Michelle. And then that appears to be Lindsay Giovanni and
Exhibit 43.
Thank you.
So when you walked out, there was a pretty raucous crowd, yelling and screaming. You're engaging with them. They're giving it to you, right?
yeah, it was a pretty chaotic situation. Yes.
And you never heard anyone yelling, liar, liar, did you?
I don't know what I heard. I only heard a couple of things being stated myself, and those are the things I responded to.
Sure. Now, in all the video you looked at, all the photos you dealt with, there's no photo, there's no representation of Mr. Carney and Ms. Gattani in the same frame or the same video. Isn't that correct?
From the photos you just sent me, no.
Everything you looked at. You said that you looked at some things to figure out what happened, right?
Well, yes, and one of the in the video that I took.
So it's a yes or no question. I'm not asking you for a narrative. I'm asking you if in all those reviews you saw any frames, pictures, stills of Mr. Carney and Ms. Gattani in the same picture or still.
So not a video, just a still of it.
Any of it.
Well, in the video.
A still of a video or a photograph. There's no picture
Photo.
where they're both in it.
No.
Remember, he has his hand.
So were you aware that day that Ms. Gattani had a restraining order against Mr. Carney?
I heard about that after the fact.
So at the time you didn't know?
No, I had no idea.
Did you speak to Paul O'Keefe that day at all?
No, I did not.
May I have one moment, please, Your Honor? Thank you. Nothing further, sir. Thank you. Thank you, Your Honor.
No redirect, may the witness be excused if he wishes to leave.
All right, thank you very much.
All right, the Commonwealth.
Council of scheduling. I'm just going to address the motion of quash.
Thank you, Your Honor.
Thank you for your patience.
The
Where are we on this right now? Have you folks talked at all? You remember the court's partial ruling is that the motion of quash is denied as relates to testimony.
Yes, he's our third or fourth witness, I think, Your Honor. And we would like to get a look at his text messages with these other people about this notion of inviting Ms. Gattani with her restraining order to this court session.
What's the witness's position relative to that motion for?
That, let me state, if I may, Your Honor, because I've sat here for a couple of days, so I think I understand case a little bit better than I did before it started. This is still Rule 17, so relevance is still relevant. At the beginning, I said to you, Your Honor, and I conceded you with, I agreed at that time, or I heard what is coming today. If I understand the facts correctly, the operative time frame is in leaving the property. I accept that there is testimony that came in yesterday that there may have been some communication with my client about arriving at the courthouse that day. But the question for this case is what happens when leaving the courthouse or back to the registry of deeds and whether there's a violation of an order. I've looked at every one of those photos, every one of those videos. My client is nowhere to be found. He was not there. He was no longer a precipient witness to those facts.
What's your position on Mr. Brado seeking some of these phone messages that you're opposing?
I oppose it. He's asked for unlimited scope on the four different people.
We're going to talk about that.
We did talk, Judge, and I narrowed the request to 30 days prior. And
what's your offer of proof of what you believe is going to be relevant from that?
Sure. So we contend, Judge, that there's a conspiracy between Ms. Gattani, Mr. O'Keefe, Ms. Jennifer McCabe, and probably other members of the Albert McCabe family to, now that Mr. Carney's out of jail, a couple days out of jail, they know that she has a restraining order. They invite her to the courthouse to kick Mr. Carney out of there and sort of exact some revenge on Mr. Carney, interfere with his reporting, etc. So what do we have for that? We have.
Let's assume that's the case.
Okay.
Where does that go relative to this charge?
That's relevant.
My role as a judge only here.
Sure.
Not a fact.
Well, it goes to credibility, Your Honor, in terms of that they're trying to create a restraining order violation.
Bad motive.
Yep.
Bad motive. Where do we go from there? Relative to this charge.
Yeah.
Bad motive.
So Ms. Gattani testified that she was invited by Mr. O'Keefe or the O'Keefe family. She involved another nemesis of Mr. Carney, Kate Peter, that she was the broker of this thing. And, you know, Paul O'Keefe is sitting in the courtroom. He's on video and it's in evidence, walking in with Ms. Gattani. And I think he's a relevant witness to what transpired and why it transpired.
He's going to be in this courtroom testifying.
Right.
But as far as the prelude to that.
Right. Well, it's a conspiracy, so they had to have communicated. And, you know, we want the communications of how this was set up to try to create a situation that Mr. Carney would fall into the trap.
I appreciate your offer. I'm going to deny the text message, Rule 17, but you are going to be able to call him as a witness. I don't know what the timing is across the street. I want to be obviously sensitive to it, but we have to move on, so we'll keep that in mind. The motion to quash is denied as it relates to him as a testimonial witness. It's allowed as it relates to documents.
Your Honor, Vice President.
Thank you.
Thank you.
All right. You rested.
Yeah. Motion for required, I'm not guilty, Your Honor. We've argued. Yeah. Oh, thank you, Your Honor. Appreciate that. So, Judge, even in the light most favorable to the Commonwealth in this case, Judge, there's no evidence of any criminal intent. There's no evidence whatsoever that Mr. Carney was trying to violate any court order. Mr. Carney did everything right. He was at his place of work. And again, no different than if he's at the Exxon station down the street in the mechanic station. He's working. She knew he was going to be there. She goes there to evict him. He goes with it. He gets up and leaves. And he walks a circuitous route down, away, and he checks in with the government. This is the key point here, Judge. This is what's fatal to the government's case. He checks in with a policeman. He reveals the situation. The policeman says, go over there for now. He goes over there. Then things change. The hearing ends early. She comes down. Hundreds of people come down, over 100 people, however you want to see it. You have the video, you've seen it. People come out. Everyone's got a black coat on. Everyone's got black glasses on, black hair. It's a sea of people. Mr. Carney's there, he's live streaming, he's talking about what just happened to him, and he's in the general vicinity of where the policeman told him to go. I would suggest that as a matter of law, the government is stopped from then prosecuting him for doing what they told him to do. And, you know, the only reason we're here is because of the poisonous atmosphere that surrounds these cases with respect to the Norfolk County DA's office and my client and the Reed matter. Any reasonable prosecutorial agency judge would look at the case and say, wait a minute, they're saying there was a violation 10 minutes ago. A cop was there 10 minutes later and they don't report it. And it's just a ridiculous scenario that if they had seen him, in other words, if there was contact, they would have made sure he got arrested. And this is all reverse engineered. They looked at the video later on. They saw that he was there. And then they called, hey, he was there. We just looked at the video. And they're trying to create contact after the fact, Your Honor. Mr. Carney is not doing anything outside of what he was told to do. He left, he walked that route, he went right to a policeman, he was told to go somewhere and he went there. He was waiting there, Judge. The evidence will show, if we have to do a defense case, the evidence will show that he was waiting there to report to the officer who was busy at the time. He didn't want to go off alone because he didn't know where she was going to go. That's his state of mind with respect to Gattani, is that he doesn't know what she's capable of. He doesn't know what she's going to do next. He just got out of jail from her locking him up for 60 days. So he wants to stay with the policeman. He stayed where the government told him. He wanted to get a chance to report and document and get the officer to take some notes and write a report about what had just happened. He didn't want to go off this direction or that direction or to a car or whatever because he didn't want to end up like Frank Keegan. He didn't want to end up at her mercy. She goes to him. She calls the cops. He had just seen that video. The evidence would show if we had to do a defense case. He had just seen that video a few days earlier, and he sees what she's capable of. He's terrified of this woman. He doesn't want to engage with her. He doesn't want to provoke her. He doesn't want to give her any ammo whatsoever. That's what the evidence showed here in the Commonwealth's case, is that he did everything right. He followed the Commonwealth's representative at the time's directions, and that should end the case, Your Honor. So that, as a matter of law, I respectfully submit, should require the court to enter a required finding based on the government's actions, based on the unequivocal, uncontested testimony surrounding Officer Crump, that he said, go over there for now, and he did that. I would ask you to dismiss the case, Judge.
Mr. Bridle has just treated Your Honor to a lot of pseudo testimony about the defendant's state of mind, and he's focused on his defense. He said very little about the Commonwealth's evidence, but if Your Honor is instructing the jury, I believe if you follow the model jury instructions, you would instruct the jury that there are 4 things that the Commonwealth has to prove beyond a reasonable doubt. 1, that a court issued a protective order. That's not even in dispute, I think. 2nd, that the order is in effect on the date the violation occurred. That's not in dispute either. 3rd, that the defendant knew the order was in effect. I think we know that, if nothing else, from Mr. Bridle's conversation with the police officer, that he knew the order was in effect. And finally, that the defendant violated the order by failing to stay 100 yards away. I'll talk about that if necessary, but in the meantime, as to Mr. Kearney's state of mind, the law is that violation of a no contact order requires no showing of mens rea other than knowledge of the order itself. That's Commonwealth versus Finalizing, 435 Mass at 312, Juror. There is no requirement of a showing on the Commonwealth's part of intent on the part of the defendant to violate the order. That's Commonwealth versus Delaney, 425 Mass at 596 to 597. There is no proof that the defendant intended an act that resulted in the violation. That's Commonwealth versus Collier, 427 Mass at 388. All the Commonwealth has to show is that there was an order that said he had to stay 100 yards away. And if he knew where she was or had an idea where she was, he didn't stay 100 yards. I said in my opening statement, Your Honor, that the defendant did the right thing when he saw Ms. Catani entered the courtroom, he got up and he left. And if he had kept on going, he would have been fine. He should have kept on going until he got 100 yards away. We can argue about whether or not going down the stairs constitutes the yardage or whether it's a straight line or whatever. But the fact is, whichever way you calculate it, when Ms. Catani walks out of that courtroom in full view of the defendant, he's about 35 yards away. And he remains 35 yards away. And by the way, he's not staying where the police officer told him to stay. The police officer pointed over towards the street, according to his own testimony.
Excellent evidence.
And thought that Mr. Kearney was headed in that direction, and then his attention was drawn to the traffic. There's no testimony that he ever came back to consult with the police officer further, or that he was afraid to leave. Rather, all the evidence, including the photos, shows Mr. Kearney following along Ms. Catani as she proceeds down the street and getting even closer to him by the end of that journey. So he's well within 100 yards. I introduced some photographs of Ms. Catani, Your Honor, that Mr. Kearney posted the next day on the blog. I think there are about 26 of them. I don't know why somebody who's terrified of Ms. Catani would provoke her by filing all those photographs the very next day on his blog. Apparently he managed to overcome his terror somehow. But in any case, I recall Mr. Bradle objecting that he didn't object to the photographs as long as there was no implication that Mr. Kearney took them himself. Well, I don't know whether he took them himself, Your Honor, but I do know that in every single photograph we introduce from those videos of Mr. Kearney, he's standing there opposite Ms. Catani holding up his cell phone camera. So he's well within 35 yards. I would suggest that not only has the Commonwealth proved its case beyond the directed verdict standard, it's proved its case well beyond reasonable doubt.
If I could just have one brief response. Nice having the case law, but you have to know the person's there. There's knowledge. You can't just be, it's not strict liability. If the government can prove they're within 100 yards of each other, that's not it. There has to be contact. There's no contact there. The government can't prove contact, and the government is, speculating about where they were relative to each other.
No facts.
They have no evidence whatsoever before you that where they were relative to each other and when.
Mm-hmm.
There's no evidence of it, and even in the light most favorable Commonwealth, they've not made it to that threshold that a rational jury would go in that direction. So I ask you to dismiss it. Thank you.
Appreciate the motion. The motion is denied. Are you putting a defense on?
Yes, Judge. Meredith O'Neill, please.
Oh, holy shit. Motion is denied. Fuck.
Meredith O'Neill?
Look at those giggling people over there.
Would you raise your right hand? Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
May I inquire your honor? Good afternoon. State your name and spell your last name. And where do you live, ma'am, just generally?
This is his.
What do you do for a living?
Yeah.
And who do you work for?
I was from Barcelona.
And what's your educational background?
And it's been French, and then the master's in accounting and MBA from North University.
How long have you been an accountant?
So 12 years.
And do you know Aidan Carney? How do you know Mr. Carney? And how long have you been dating? How long have you known him?
Years.
You know that he's charged here today with violating a restraining order, right?
Yeah.
And you were with him that day, weren't you? Tell us how that came about, that you and he were together and coming here on, coming to Dedham on 2/26/24?
There are motions that the Karen case, we both have obviously been following the trial for quite some time, so we decided to attend the hearing together.
And just so, just for the record, so the factual background is clear, Mr. Carney is probably the most prolific commentator and journalist investigator on the Karen Reed case. Is that a fair statement?
Overruled.
Yes, that's a fair statement.
And you actually do too, right? You
Yes.
comment on Twitter or X about it here and there, right? And you guys, you assist him with that endeavor as well?
Yes, sometimes.
Sure. So on that date, there was an afternoon hearing on the Reed matter, right? And at the time, Mr. Carney had just gotten out of jail a couple days earlier, right?
Yes.
And that was from a case that was out of this court, right? You know a little bit about it, right? And that you know that the charge in that case was among the charges in that case was a charge of assault and battery, right?
Your Honor, this is Mr. Brady's witness.
He's leading.
I'm just trying to move it along for some preliminary matters, Your Honor.
It's leading, but it's all anecdotal. We all know most of this anyway. Let's go.
So on the day of 2/26, how do you and Mr. Carney come together?
To court together with our grad goals.
And what was the plan that day among you guys to watch this hearing?
So, work on it. So we got there then.
Where did you park when you got here?
I parked in the road.
And did Aiden have a car in some other location as well?
Yes, about 5 or 10 minutes down the road, he in park. So I met him coming from his house and then together.
Then you drove together closer.
Close, correct, to the Red Street.
And where did you park your car?
In the Red Street park.
So in like the back of the building, behind the building?
Yeah.
Did he leave some items in the car when you guys departed the car?
Yes, his computer and his car key.
So what was your path, the three of you, what was your path to the Norfolk Superior Court?
Into the courthouse, we walked around, I believe this building, between this building and the Red Street, across the street, we crosswalked around 1:30.
Was there anything unusual that occurred in the walk, or was it just the typical assemblage of people outside?
Not at all, very typical. Reporters carrying and being outside.
And did you have some conversation with them, or did you see Mr. Carney having any conversation with them?
Yes, many conversations.
Do you know who Lindsay Gattani is? And did you see her outside anywhere during your arrival into the courthouse?
No.
What happened when you got into the courthouse?
About 1:30, we weren't letting go in just yet, so we went to security and then went upstairs and waited in the line before they started letting people in the house. And then before they started coming.
Did you and Aiden and Mr. Goldstein, did the three of you get into the court hearing?
Yes, we did.
And where did you go when you got in there?
That is the third, towards the outside. So,
And if you were looking up at the bench, at the judge's bench, were you on the left or the right?
we are on the left side.
All right, so kind of near the windows on the left. Did you sit in the same row as Mr. Carney or a different row?
Same row.
What time did you sit down roughly, if you remember?
But would have been 1:50 short before we lost our time.
Did you have any knowledge of the hearing that was about to commence and what kind of a hearing it was?
Yes, it was a motions hearing. There were several motions to be heard, including a vote.
So was this the type of a hearing that you anticipated would be 5 or 10 minutes or a longer type of a hearing? So you were sitting down. Did the hearing commence at about 2:01 in the afternoon? And right around the time that it commenced, did you see Miss Gattani? And where did you first see her? All right. And just to summarize, you've seen video of this and you're aware that there's video and evidence about this very snapshot of time, right? Okay, and you remember it though, right? All right, so we're gonna just go with your testimony. So when you turned around and you saw Ms. Gattani, what did you see? Set the scene for us.
Right away, identity, and right now I'm being not McCabe and it's other family members. So we noticed identificating her and was turning and said she's going to be here immediately now.
Did you notice whether she had anything in her hands? Did you make any eye contact with her or communicate with her in any way?
No, as soon as I saw her from the bar, I just go down.
When you turned around to see Ms. Gattani, you were looking kind of towards the back of the room?
Yeah.
You kind of had to turn over your shoulder. What about Mr. Carney? Did you see him, whether he was looking with you or whether he was looking straight ahead?
That was not her. I was just looking to see who was coming in, just wanting to see if it was the judge gave it to other witnesses that he.
Okay, just listen to the question you're asking, just answer that question, and then just wait for the next one.
So when you, right at this snapshot of time, when you're looking back at Ms. Gattani, you see Mr. Carney. Did Mr. Carney react in any verbal way, to your knowledge, when he saw or you saw Ms. Gattani?
No, correct.
Did he get up?
Did get up and said, God, that
Was he facing the direction of Ms. Gattani when he said that, or was he facing the direction of some other people in the rows?
stay forward.
And what happened next? Right next.
Thought out. Standing in there between us, the crowd standing between us, and we left, walked out the door, and downstairs.
Did anyone have to tell you or Mr. Carney what to do?
No, I told him to leave the left, not speaking at the door.
What was the time period that went by from the time Gattani walked in the room till you and Aiden had walked out of the room? Where did you see Miss Gattani go when she came into the room, if you saw?
I did think, like,
Did you see, do you know who Paul O'Keefe is? Did you see Mr. O'Keefe in there? If you remember.
don't believe so. I mean, looking at videos after the fact, and I can't say that at that time, when I was walking out, I saw any of them because I was just focused on getting out.
Sure. In the 10 minutes or so that you were waiting there, can you recall looking around the courtroom and seeing who was around?
I think some of you have been there before, but that's certainly not Mr. Tanya or Jeremy Davies walked out after that.
Sure. So you leave with Mr. Carney out the door of the courtroom.
Correct.
Where do you go?
Head downstairs, security area where we came in, and a couple people stopped us and talked.
You still listening to the question or not?
So you walk outside and you're going to leave the courtroom?
Yeah.
As you guys leave, did anybody from the Alberts or McCabe's or O'Keefe's make any comments about you or Aiden having to leave?
Objection, relevance, overruled.
What did Chris Albert say?
That at the ITPH, that we needed.
Where did you go, just physically, where did you go when you left the courtroom?
Right downstairs.
Did you speak with anybody as you were leaving?
One woman, even.
Okay. What was Mr. Carney's kind of demeanor when he was leaving?
Objection to the characterization and to what he wanted.
Or the anxiety stays, the rest doesn't. Question.
When you say he was in a state of anxiety, can you give us some things that you observed about him that made you conclude he was in a state of anxiety?
He told me he was worried and followed him out.
So you get down the stairs to the first floor, and what happens on the first floor?
A woman approached us and some information about entering the courthouse before.
Do you know that lady by any chance?
Yeah. So,
Was that in the vicinity of the metal detectors, or where was that on the first floor, just generally? Did you stay with Aiden for that, or did you go ahead of him, or were you still together, or what? You exited the the front doors of the courthouse? And what was the scene that you first saw when you went outside?
there was just a smaller crowd of people outside, smaller than a lot of people thought to be hearing, but when you surround people, were also police officers.
Approximately how long after 2 o'clock were you guys standing outside?
Probably within 2:06.
A few minutes after 2:01 or so, a few minutes later. What did you see Mr. Carney do when he came out of the courthouse?
He immediately walked up to a police officer across the street,
And where was the police officer?
directing traffic in the crosswalk.
Okay, so that's kind of is that a busy area there, or is that a quiet area? So did Mr. Carney stay on the court side of the street, or did he walk to the registry side of the street?
He walked to the register side.
Did he try to have a quick conversation with the officer? And what did you see?
The officer, things were straight over to completion, the officer said, go over there for now.
And did you see any physical gesture that accompanied that statement?
Pointing towards there.
Okay, so he kind of made a physical gesture pointing in that direction. And did you see Mr. Carney do anything in response to that gesture?
He went over towards the registry, the actual building.
All right, and did he, where did he stand in relation to the actual facade of the Registry of Deeds building?
He was all the way up against the wall, far away.
Okay. Did you and Mr. Carney intend to do anything at that time period to memorialize what had just happened inside?
Action to what she did.
Objection sustained. It's to the form of the question.
Sure. What was the plan between you and Mr. Carney about what to do about what happened inside?
Again, I memorialized what happened in there to ensure that this could happen, he was going to see what happened and make it found, this down and be some type of violation.
At some point, was Mr. Carney reporting, doing his job, I guess, about what had just happened to him?
Yeah, started live stream of the courthouse, and we both agreed with the idea so that everything was documented in case we could kind of see back out all of those.
And what is live streaming?
It's just when you have a camera and you project a live video to an audience, whether it's YouTube or a platform.
Was Mr. Carney live streaming, to your knowledge, as he came down the courthouse steps? Was he live streaming when he was talking to the officer?
Yes.
Did he continue to live stream as he followed the directions of the officer? When he got to the facade of the registry, was he still live streaming? All right. Did you want to get involved with him in his live streaming at the time?
No, I purposely kind of stayed out of the church that on.
At some point, did hundreds of people stream out of the courthouse? How much time had passed between when, let's say, when he gets to the facade and then when hundreds of people come out of the courthouse?
Probably March.
Was that an expected, strike that? Was that the departure of the folks that you saw in the courtroom earlier?
Yeah.
Did you expect that hearing to end, causing all those people to leave?
No.
Good. Good.
Still in there, with us.
You mentioned that the officer that Mr. Carney spoke with was in a little bit of a busy area, right? Did it get less busy or did it get more busy when those hundreds of people came out?
We got for
With this event occurring, did it get more difficult or less difficult to get the officer's ear to get something going with respect to police report?
them.
And was Mr. Carney continuing to live stream
was for a period of time, yes, but yeah, so.
Did many of those hundreds of people kind of come across the street to the registry? Do many of those people know and communicate with you and Mr. Carney? And they do typically on a regular basis. These are people that you guys know, supporters, friends, colleagues, acquaintances, right? Did you and Mr. Carney kind of separate off from each other in terms of talking to these people and doing whatever you guys were doing?
Yes, okay.
And where were you and where was he, to your knowledge?
Still around that same area, there's a security officer in there. So at one point, my friend Brad, my team was, but he wandered a little bit towards the parking lot.
At some point, did you see Lindsay Gattani and her group come out of the courthouse? Was it something that was open and obvious, or was it something that was mixed in with everyone else coming out? Was there something unusual about, you know, the colors? Was there contrasting colors? Was it a majority of similar clothing, or what was the scene?
A lot of dark winter, but black winter.
Did you, at some point when they came out, when Gattani and her group came out, were you paying attention to Mr. Carney at that time?
I don't know exactly, but the only time I saw her was when I went back to my car parking lot, stuff was there.
So before you left, did you, and when you were in the vicinity of Mr. Carney, did you ever hear him calling anyone a liar, screaming out liar, liar? Did you ever see him make any outward manifestations that he had seen or spoke to Ms. Gattani?
No.
And was he still live streaming?
Yes.
When you live stream, do you hold up your phone in the similar fashion as you would when you're videoing someone or photographing someone?
Hold up.
So just is it a similar way or is it dissimilar?
It's different.
And was he doing that to your observation that day? So you were able to discern that he was holding it towards himself versus memorializing the scene. At what point do you and Mr. Goldstein decide to go head towards the rear of the building?
Within a minute or two of everything. He gave his value, he got it, and then he went to my car because he wanted it still there.
Okay. So, did you say that you saw Ms. Gattani in the back parking lot?
I did. She was already there by this. I didn't need to see her. Brad, when I stepped out of my car, Brad pointed out that there she is, and it took me a few minutes to even represent to be able to recognize her. With another group of women and pretty much wearing the same thing, so it just took me a lot far to see her. But
She was parked all the way at the far end of the registry of each parking lot, right?
further towards the end than I was, I was closer to that level.
More than a football field away from the registry building, or about a football field, or less than a football field from the registry building? From the
More.
back of the registry building.
It's 100 yards. You have to say more.
So she was almost to the back of that registry parking lot?
Yes.
Was the rest of her group also parked there and
Football
congregated
field's
there?
100 yards, guys.
We're all congregated in the other parts, but they are.
So if Mr. Carney, when he left, if he had gone to the back of that parking lot, he would have been going right to where Gattani was going.
Sure.
It was the same location as where Gattani went, right?
I got the picture. Next question.
When Mr. Carney went to the back with you, was Gattani still there or was she gone?
That was much later. No, I went back and found him. When I saw her back there, I needed to text him and said, do not come back here.
Okay. So then you go back to where Mr. Carney is?
All the way on court. To the right of Superior Court where Karen Reed's entertainment park down that way. So
All right, so he had departed and gone the other way. And that would be, as you're looking at the North Superior Court, the street to the right along the side of the court, right? And you went and found him? Did you bring him his items? When Ms. O'Neill, is the first time you saw Mr. Time?
Bradle should have had a map.
Departing the court?
in the parking lot.
In the back of the building?
Yes.
Okay. What were your observations of her demeanor? Was she gesturing? Was she looking back? Was she looking forward? What were your observations? Did anyone in the group appear to be agitated or upset by anything that may have transpired?
No.
May I have one moment, please? Thank you very much, Ms. Nothing further. Cross-examination.
Okay, let's hear this cross. Speaking of the mic, Gramps.
Now, I think you told Mr. Bradel, no, kind of for a couple of years and that you've been dating 8 months, that's right?
That's correct.
Did you know him when he was dating you at the time?
Irritated.
Really? You don't much like Mr. Time, do you?
Although, some people lie.
That wasn't the question.
See?
Did you hear the question?
Yeah.
What was the question?
Do I like Mr. Tanya?
Yes. Now try my question.
Of course, I don't think so.
Thank you. Did you execute an affidavit, Ms. O'Neill, on June 5th of this year?
I did.
And did you say, Ms. O'Neill, paragraph 3? Actually, I'll show it to you first. And you can ignore what I circled. Take a minute to read that.
Okay, number 3.
Yeah, just read it to yourself. So did you say in number 3 of your affidavit at approximately 2:05, I turned around and saw Lindsay Gattani into the courtroom holding a white piece of paper in her hand. Immediately told me we need to leave. We were surprised to see her there because she never attended Karen Reed meeting prior to that and was not friends with any of the witnesses or victims' parents.
Correct.
By the way, have you attended all of Karen Reed hearings at that point?
Most of them, not all.
Then you don't know your personal knowledge whether Mr. Tommy was setting it
fuck.
service or not, do you?
I do watching this. I watched every single hearing.
Oh, you kept a vigilant eye. So at the moment that Mr. Tommy walked in, you checked out every single person in the courtroom?
Well, at that point, she said, also you would know if she was there.
Good answer.
I'm not sure I see the connection, but maybe if I think about it, it will become clear. Now, did you happen to read an affidavit that Mr. Kearney wrote?
One,
This one.
Does I object to impeaching a witness with someone else's statement?
See what the question is going to be.
Good objection.
well, I'm not familiar with all of it, but there's a lot of specific things like that. I'll take a look.
Just
Just wait for a question. You don't have to respond.
Did you happen to watch, did you watch all of these attorney shows? Do you remember whether you watched the Saturday Night Live show on February 24th?
I don't remember off the top of my head, but that was so long ago.
Well, did we agree that February 24th of 2004 was 2 days before February 26th, and you're in the United States?
2024?
Yes, right, when,
Yes, I agree this is to be.
thank you. And do you know that the state attorney said that on that live show, he announced that he would be defending Karen Reed here in the was very important with that.
You're saying that very enough.
And do you know that he
Excuse it, give me one. Witnesses don't have to agree or disagree, just whatever you know or don't know.
And you know that he stated that on that show, he expressed concerns that some aides and Alberts would show up with Lindsay Vitale as human shield in order to remove him from the courtroom due to the restraining order she had.
I don't remember saying that.
Well, still for the moment, he did.
He did say it.
Can you explain why, in light of the fact that he's broadcasting on the live show 2 days before the ceremony, he's worried about Lindsay Vitale showing up?
It's not.
He was surprised to see Lindsay walk into the court.
Okay, sustained. No, excuse me. The objection is sustained. Next question.
You could still be surprised.
So you and Mr. Carney see Lindsay Vitale come in and you get up and you leave. And you go down the stairs and out the door of the boat. Is that correct? And at what point does Mr. Kearney start live test?
As soon as you come outside.
Stepped outside the courtroom or stepped outside the building? Okay. And that was always the plan, was it not? What's the point of the visit? Was the training was to do a live cast on the scene?
I don't know.
He does them in his car.
Did he pretty much always do that? And that was the camera meeting?
Before, I almost got that.
This guy's a fucking piece of shit. Imagine him out with some Viagra. Honey, you see these papers? You see this dick?
Camera on him to document what's happening downstairs.
I told you I want to document what happens there.
That's the time he followed him. He wanted it on camera.
Oh. So you're outside of the courtroom, he talks to the officer, and the officer directs him, you say it's registry. You hear the officer say registry of deeds?
So he said go over there and point the registry deeds.
Oh. Stop and point like this, or was it just
Pointing at the building.
straight ahead?
Absolutely.
Wasn't pointing at Ponson.
I don't know.
Mr. Kearney goes over there. Are you still with him at this point?
Yeah.
Are you standing next to him or nearby him by the registry of deeds building?
Five. Not sure.
And you're familiar with the Norfolk Superior Court, the entrance and the exit, are you not? And you've attended a number of the hearings that you've seen. And you know that typically when the hearings get over, people who have attended the hearing, quite a number of them can't leave your death. Would you agree, quite a number of people typically attend Karen Reed hearing? And on this particular day, it was so crowded, everybody couldn't get in, right? So you know when the hearing ends, what typically happens is the people go out that main exit door, same when they went in, right?
But
Now, at some point, you notice that people are coming out the door, right? Are you standing next to the defendant at that point?
For a little bit, you're still a little bit away, the crowd started.
Oh, well, did you observe whether Mr. Kearney, who was worried that Mr. Conley might follow him, was looking at the jeweler at the door, was in the position to notice the crowd coming?
On his camera live streaming himself.
So is it your testimony his view was totally obstructed by the phone?
I can't tell you what he was thinking at that point, because I was having a conversation.
Well, you've been very good about telling us when I'm soaking it up.
Counsel, should we wait for her to answer the question? Thank you. You can finish your answer.
I can't tell you what he was thinking about his assessment of what was going on outside. I was having a conversation, were rushing up to me, he's on his phone, so.
So in any case, you noticed that people were coming. Did you have any reason to believe that Ms. Catani would not be coming out that door with the rest of the crowd?
not at that time. I would
What
say
was the question on that?
what? What kind of questions are these?
No. I asked you, did you have any reason to believe that Ms. Catani would not be walking out that door with all the rest of the people who attended the camp?
Objection, Your Honor, is inviting speculation, someone else's state of mind.
I'm sorry, I didn't mean wrong, but I'm just.
What was his objection?
It's speculation, calls for speculation.
Okay.
He sustained it too.
Well, at that point, did you say to Mr. Kearney, I see people coming out. I see people from the Karen Reed hearing coming out the door across the street. Did you say that, John? And you're only talking when you're directly next to.
I was talking to other people.
So you have no concern at all for Lindsay Gattari to come out and pursue him and get him in trouble. You weren't worried about that at all at that point.
I was trying to figure out what happened because
I didn't ask you what you're trying to figure out. I asked you if you were worried at all that Lindsay Gattari would come out and pursue him. I thought that was your big worry. Did you tell Mr. Brady that? You and Mr. Kearney were very
I
worried.
just would like her to be able to get an answer. And
One question at a time.
Yeah.
Yeah, we were concerned about that. For the next time, let them out.
And you didn't take that and believe this one, please.
No.
No, I didn't ask you why.
Who's?
So you don't tell Mr. Kearney that people are coming up. You don't call that the other attention. Because you're talking to somebody, or for whatever reason, you don't call it to this.
What?
And you don't say, hey, Lindsay might be coming out that door. Why don't you go back to my car and get the hell out of here so she doesn't track you?
I hadn't seen her at that point.
So was it your plan to wait until she was on top of you before you left?
No, this is a conversation between the secretary and the president.
Well, it hasn't, right? People were coming out the door regardless of your expectations. You could see that, could you not? And in fact, before people even started coming out, you were so worried about Lindsay. Why didn't you say, Let's go back to my car and get the hell out of here, so there was some problem.
Why should you more than police report, so that's fire and what they tell you.
And there was a police station in the town of town.
Everyone else.
Objection to relevancy with that. What's irrelevant what the fuck she says?
And you know, when this.
Or what she was thinking. Like, why didn't you say this to him? My answer would be, well, because I knew we were 100 yards away.
Relative to that thing.
That's the answer. We were 100 yards away. We weren't violating. We weren't doing anything wrong.
So you couldn't leave because you wanted to file a police report, but then a couple of days passed before the security gets there. Is that what you're calling it?
At that point, it's already started with this, so.
But you think it would have been approved to get it recorded before she did?
He did, like, that night, so.
So you would say she was very quick about reporting the alleged violation?
Not when it happens, not until later.
This is the benefit of a bench trial.
Bit of a long too.
I don't know. We'll see. He's like, can I have a moment here? What does he need to look at? I mean, I would love to know what kind of prep went into this. I'm just going to tell you 0%. Not much.
Up against the wall of the registry of deeds. Yeah.
No, we actually went out to the Work Street, like this guy texted them, "Do not come back here in the parking lot."
Well, when he starts moving, he moves in the direction of this court, correct?
No, we moved around the back towards Superior, down Court Street.
Really?
Okay, this all has to do with violating a restraining order, which is 100 yards. Okay, so why wouldn't there be a map here to be talking about how far everything is?
15, please.
See, I'm all over here wanting to put on like the best.
Remember what Mr. Kearney was dressed as that day? The blue tie, dark blue tie. You see him in that photo, goes to the back. At that point, he's not in the front of he's not on the steps of the registry of deeds.
The road of the steps, I can't tell where exactly he is from that photo.
All right. Well, would you say, looking at the registry of deeds building, would you say he's moved to the right or he's moved?
Judge, I object. This is all speculation because we don't know where Mr. Connie is. We don't know when this is.
Objection sustained. I don't need to give a open. You can't tell, can you tell from that photo what direction he went? Yes or no?
No.
Next question.
All right. I'll take a look at 16, please.
They're using Turtle Boy's videos and like where he was at.
Well, wherever he is, it's fair to say he's not on the front of the registry of deeds at this point.
I can't tell where he is. It doesn't look like the front of.
All right.
If they're doing that,
Let me
he'll
move
win.
on to another line. Question.
If they're doing that, he'll win because his videos prove he wasn't in their vicinity. He didn't break anything. He didn't break the rules.
He had his cell phone.
It depends how close he was to her. That's all that matters.
Obviously, that his cell phone. Did you ever call him suggested it was a good idea with the call.
I was not sure it was there.
He wasn't close to her.
I didn't call him, but I went down and asked her to sit.
Whenever you're in the courthouse or whenever you were outside.
That is your general. I can't do terrible service.
Who's your carrier?
Thank you.
And when you were there were a lot of people in the crowd shouting words. And you were, at times, you were some distance from this attorney.
Yeah, and then we went back to the parking lot.
Right. So you really have no idea whether he happened to shout liar, liar, or somebody at that time.
Well, by the time I got to the parking lot, Mr. Connie was there, so we couldn't have found it.
And when you were apart from Mr. Kearney, were you down in the parking lot the whole time, or?
For most of the time, and then walked back, yes.
I think Meredith has 4 kids too, so she's got to be, you know.
Before you got to the parking.
For the parking lot, we were most of the time.
I'm sorry?
Before I went to the parking lot, which was when we got separated, I was with them most of the time.
You were most of the time very mostly. All right, so the answer to my question, which was you weren't with him at all times, is yes.
Paul didn't take the stand yesterday.
Oh, did he?
So the text message, do not come back here.
I got told that hard if I didn't believe him, if I believed he did. But he didn't.
Thank you. No further questions.
Just a brief question, Your Honor. So you were asking Ms. O'Neill
There you go. He opened the door for this.
about why didn't you go find the police station and report it afterwards? Something to that effect, right? Were you in the car with Mr. Carney for a little while after kind of this whole thing had subsided? Was he in any sort of state of mind to be able to report anything to the police?
On the verge of tears, I mean, go get his head.
I'm sorry, I didn't hear you.
He was on the verge of tears, he was shaking, and he was trying to calm down enough to be able to go, he pick up the kids.
All right. And is that why you didn't pursue any police documentation at that point?
All through. No.
Thank you. Nothing further.
Yes, correct. And on the verge of tears and that's fun.
Yeah, he was live. He's an entertainer.
I wasn't crying during the live broadcast. The live cast he was doing across the street, Registry of Deed.
He has to
So he
still,
only collapsed into this emotional state
he has to still do his job.
after he got that.
Meredith has $1. Thank you.
He held it together bravely during the broadcast with no proof questions.
No further.
You may step down, thank you.
Judge, sets to break. I have a very quick witness who's got to pick up her kids, and I was hoping to maybe just get her on for 5 minutes or so.
So that happened across, but we'll start it.
Sure,
Go for a
appreciate it.
short period of time.
Thank you, Lauren Cologne. Lauren Cologne.
Lauren. Okay. I can testify to that. Listen, he still has to do a job. That's why it takes
Lauren Cologne. Yep, thank
to
you.
be able to be an entertainer and be on the mic and show your face and
Good morning, if you raise your right hand.
Be yourself.
Now I'm hearing you
Well,
tell the
what's
truth.
going
All
on?
truth and nothing but the truth, so help you God. Thank you.
that doesn't mean you're fine.
May I inquire, Your Honor? Ms. Cologne, good afternoon.
It means you're good at your job.
State your name and spell your last name, please.
Oh,
And where do you live, just generally?
in the North Park County.
What do you do for a living?
I am a project manager at a large company. I work out of their headquarters.
And are you married?
I am.
Family? What's your educational background?
I have my undergraduate and an MBA degree both from Northeastern University.
You've taken an interest in the Karen Reed and Aiden Carney cases here in Norfolk County?
Yeah.
And from time to time you attend these hearings?
I attended one here.
Was that 2/26/24?
That was.
And you were there inside the courthouse or outside the courthouse when that Karen Reed hearing was going on?
Okay.
Shortly after 2 o'clock, were you outside the courthouse? Do you know who Aiden Carney is?
We do.
And it's the gentleman here with me, right? And did you see him emerge from the courthouse a little bit after 2 o'clock?
I did.
And what exactly were your observations? And first of all, where were you situated when you first saw him?
Yes, I was on the stairs. It was the first stair or two leading up to the courthouse doors.
Okay, so the base of the stairs at the Norfolk Superior Court main entrance. You see Mr. Carney. What do you see?
Mr. Carney came out. He looked visibly anxious, very, very anxious. He had really a great concern that was.
Objection. Anxious will stand. Next question.
Was he using his phone at all?
But then I did observe him make a comment that I should.
Objection to the comments.
You answered that question. What's your next question, Mr. Brennan?
What did you see him do, just physically with respect to his phone? Do you know if he was recording out to the world or recording himself? If you know.
I believe he was recording himself.
Where was he when he started to do that?
I want to say, maybe it was like around the base of the stairs. Maybe leading out into the sidewalk.
I'm sorry. Okay. When he came out, did he draw your attention or were you looking at other things besides Mr. Carney or anything?
No, I was looking.
And what did you see him do and where did you see him go?
Well, I saw him, there was a state trooper that was there.
Objection, my question is, what
What
did you see him
the
do?
question? Thanks. Yeah.
What did you see
Listen
him
to
do?
the question and just answer that question, please.
He began moving down the stairs and started to cross the street. He approached a dead police officer.
You were going to talk about a state trooper. Did a state trooper approach him as well?
Yeah.
What
the
happened?
State trooper was concerned about.
Objection.
Just what did you see happen?
So I saw the state trooper usher folks off the stairs and to continue moving across.
And was Mr. Carney part of that group of people that were being ushered around? Where did he go?
He then was walking into the street. He approached a Dedham police officer.
Was that Dedham police officer busy doing things or was he just completely focused on Mr. Carney?
No, there was a lot of people around.
Next question.
Did you see Mr. Carney speak to him?
I did.
What was said?
I
Notice and knowledge of mind, state of mind.
Grounds for your objection.
Seriously.
Here's
And it's also already in evidence. Your Honor's used the recording of the conversation.
Overruled.
What did he say to the officer?
I did not hear what was said.
Next question.
What did you see as far as any physical gestures by either Mr. Carney or the officer?
I saw the officer lift his hand and point towards the registry of deeds. I then
Next
saw.
question.
And then what did you see Mr. Carney do in terms of gestures?
I saw him do the same.
And where did you see Mr. Carney proceed after that?
He then walked over to the registry.
Was he still doing his thing with his phone?
Yeah.
at some point, hundreds of people stream out of the Norfolk Superior Court, right? Was it close in time after this interaction?
It was.
What did you observe about people streaming out of the court?
Just generally, I really didn't observe. I don't know.
Okay, was there a large number of people or a small number of people?
It was a large number.
Now, were they going towards the handicap ramp, down the main stairs, or where were they going in general?
There were folks using both the handicap rail and the.
Did you, were you near Mr. Carney when those folks started to stream out of the courthouse?
No.
Did you see Mr. Carney doing anything else outside the courthouse when these folks were coming out of the courthouse?
I did not.
I just have one more, please, Ron. Thank you very much, Ron. Nothing further. Thank you.
I'm curious about his questions for her.
I want to know if that other video made it into evidence yesterday or whenever. That's not Turtle Boys. It's someone else's perspective also of what happened.
Friends,
I see is Institute.
just once.
No.
When was the most recent time? So.
Last night we had one of the jurors from the first year trial.
What?
And you watched others as well?
Yeah.
You have a paid subscription to any of these channels, some of them are free, some of them are paid.
No.
And can I ask you if you executed this affidavit of March 6th?
She filled out an affidavit.
Yeah.
And, how did you come to run this affidavit, or how did you come to execute this affidavit?
I not recall if somebody sent me a tweet or if I saw it myself, but it was basically a request from Mr. Carney. If you were there, let me know if you're going to give your observations.
So he put out the request and you responded to it?
Yes, I felt as
Don't tell me what you thought.
Yes.
Answer the question. So, after you responded, what happens if you're food?
I sent it over to the paralegal who works for.
Did you draft the whole application yourself, or did the paralegal before you worked?
I drafted it mostly myself. She cut out parts of it that I had originally drafted.
What?
All right. And then you read it over and signed it?
Yes.
So some of this language, like I am of age and resident of Commonwealth of Massachusetts, that's not your language, right?
Objection, Your Honor. Legally, she signed it and adopted it. It is her language.
Overruled. Do you understand the question? Were you the one that wrote that, or was that suggested with writing that you signed?
I wrote the affidavit.
Thank you. No further questions.
Something on you?
Nothing further. Thank you.
Thank you, your excuse.
Thank you.
Congratulations.
Court's in recess until 2 o'clock.
All right, continue to the front door. Thank you.
Zoom will resume at 2 o'clock. Thank you.
These people are absolutely nuts.
Yeah. of course.
Dude, this is literally a court for a protection for a violation of a protection order the Commonwealth is seeking. Let's see what. Oh God. JLR posts.
So I'm curious because, you know, Turtle Boy is from the area, right? And if him and his attorney, who's from the area, decided for a bench trial, it's very telling. And for those of you coming in late or who don't know what a bench trial is, a bench trial, you as a defendant can stipulate to having a jury trial or a bench trial, which means that you just want the judge, not 12 angry, 12 random people choosing your fate. So you have a judge do it. Sometimes it works in your favor. If you know the judge, the attorney knows the judge, and they're like, oh, they're going to like totally rule in our favor. Or if you know the county. So I think it's very, very telling here that this is what Aiden and his attorneys decided to go with. I don't know if I would trust there not to be corruption by having the, you know, the Alberts run Canton, right? And he, remember how he like was saying he got on his video camera? He's intimidating him because Turtle Boy walked by and like did faces.
Turtle Boy's calling Paul O'Keefe to the stand.
Oh God.
So that's happening. Want to talk about what JLR was doing.
JLR has been going at Turtle Boy. So is he doing it again?
No, to both. This is about Karen Reed though. Hold on. He does a poll on if this will be Karen Reed's last weekend as a free woman. He said, will this be Karen Reed's last weekend free? P.S. She has a 0% chance of being acquitted.
He gets nuts sometimes.
Oh my God. Wait, let me just put these answers in here. Megan Smith, whoever the fuck she is. Okay. I feel like the Commonwealth proved their case beyond a reasonable doubt, but it all depends on if the jurors can see past the theatrics of the Three Stooges.
Oh my God, get a life. Just don't read me anything naughty about the defense because I can't handle it.
JLR says, not all the jurors. She will never get all 12 to find her not guilty of all charges. Then James said, Winchester said, you're delusional. He clipped the lawyer you knows. They had 11,000 votes. He clips the lawyer you know's poll, and it's not guilty 85%. 3% say guilty. 4% say lesser included, and 8% said hung jury. Then, I mean, so then Chris John writes and says, 0, you say, question mark. Then JLR writes back and says, yes. Are you sure you are comprehending my tweet right? Tell me you didn't watch the trial without telling me you didn't watch the trial, says Free Karen Reed. I do not see 12 coming to a consensus regardless, says ZCAT ZM30W. But I don't know about trials in depth. Can there be a second mistrial? Yeah, there can be as many. What else?
No, like you should read, like he was making me laugh when he was going at Aiden because he like got the biggest balls to like, he just like drops balls every once in a while that I didn't know JLR had. Like, didn't want to like drop a ball. But no, these people are delusional. There's no way you can watch this shit show and think the CW proved their case. I mean, Welcher had a glass in his hand and he had his freaking hand painted yellow. And then he painted his arm blue.
Here's the next thing he did one day ago. Not only is Karen Reed guilty. Okay. I'm going to have to mute you now. Okay. Not only is Karen Reed guilty, but she is also a coward. And he posted, Karen Reed will not testify. I want to see. He's not writing anything about Aiden.
That'll happen when I'm in the middle of a thought and you cut me off when I'm laughing. I'll still be laughing. I'll mute myself.
Well, 2 days ago, Karen Reed, the idiot who didn't take a plea deal. Oh my God. JLR, thanks for the shout out, Grok. He was quoted by Grok on Twitter. There's some question about, I don't even know what this is. It says, I lean towards agreeing we'd still know about the LA protests. X has been a hub for real-time updates with posts like those from @JLR Investigates showing live chaos. When you get Grok to fucking quote you, that's pretty crazy. Grok's no joke. But damn. A lot of Bella, why aren't you down in LA riots, man? Get a camera down there. What's the verdict on what's the curfew like down there right now? Okay. Well, I'm gonna go like this. Alrighty. Back over here. We're gonna pull up nice little wah, wah, wah. They're gonna resume at 2 for Aiden. Jeez. All right, so then I'm gonna go ahead and start an Aiden thread at 2. Join me back at 2. I'll start a Turtle Boy thread. Thank you guys. Appreciate ya. Peace.